Why couldn't Congress prohibit Americans from associating with certain foreign organizations that have interests that are hostile to the United States? I mean, I thought that's what Holder versus Humanitarian Law Project allowed. So I don't really understand what you mean.
Right, so I'm glad you're bringing that up.
Yes.
So when it comes to national security, you are right that Congress can prohibit Americans, to use that case as an example, from associating with terrorist organizations or other organizations that pose a clear and present danger to this country. This case, Justice Jackson, is fundamentally different. What the government tells you in its own brief that it is worried about here are the ideas that might be expressed on TikTok. We might undermine U.S. leadership. We might sow doubts about democracy. We might have pro-China views. And so if you look to whether that is legitimate interest, my fundamental submission, and this I think goes to the last colloquy you were having with Mr. Francisco, is that is an impermissible government interest. And you look throughout our history and tradition, and I think the place I would point you most directly would be the opinions of Justice Brandeis and Whitney and Justice Holmes and Abrams.
I guess I don't understand how that's distinguishable from what's happening in Holder. So can you just say a little bit more?
It goes to the nature of the national security threat. So my position is the government just doesn't get to come in and say national security in the case is over, or you don't get to associate. You have to dig underneath what is the national security claim. And what Justice Holmes said in his Abrams dissent, and I know that was a dissent, these are hard issues, but that has been vindicated over time, is that it's not enough to say national security. You have to say, what is the real harm? Is it, is it terrorism? Is it where our battleships are located? Is it war?
Justice Kavanaugh presented a number of potential risks, right, with foreign adversaries using covert manipulation of the data platforms that are being used by youths today that would then make it more likely that people would turn into spies and do terrible things to the United States. This is a hypothetical, but you know what I'm saying?
I get it. So I think if I understood Justice Kavanaugh correctly, he was talking about the data security argument. So let me just pull these apart. You first have an argument, and the government itself separates these two arguments in its brief. The first argument, the one I'm focusing on initially, is the content manipulation argument. And that argument is that our national security is implicated if the content on TikTok is anti-democracy, undermines trust in our leaders. They use various phrases like that in their brief. So my primary submission is that is an impermissible government interest that taints the entire act. Now there's a secondary argument the government makes, and we say you don't even get to that because once you have an impermissible motive like that, the law is unconstitutional. But even if you could get to that, Justice Jackson, I do grant that data security and the way Justice Kavanaugh spelled it out is compelling. That is compelling, but that's not the question. You just don't ask in the air, was Congress worried about data security or could it reasonably be worried about data security? You say, can this act, the act before you, be sustained on data security grounds? And our answer to that has to be no. You don't have to look any further than the divestiture provision itself, which says that the content recommendation algorithm cannot be used in the future. Well, that has nothing to do with data security. So the core feature of the divestiture provision is going at content manipulation, which I said is impermissible. You can't uphold that under data security grounds. And the rest of the act, when you look at the covered companies provision, Justice Jackson, if this were primarily a data security law, what you think you'd find is what kind of data is procured? How is it stored? Is it shared? Those are the things you think you'd find under covered companies, but you don't find that. What you find is, are text images shared? Is content being shared between users? Is it being created and posted in a social media platform? So I don't dispute for 1 second that data security is a very important thing, and Congress in this very law regulated data security in other ways with data brokers. That's perfectly permissible. But the question before you today was narrower. The question is this law before you sustainable on data security grounds? And that answer has to be no.